asking questions and we can sort of talk using the same language. I just live down the Parkway, so that's why I'm here. And I have a young guy that cuts my grass, and he also raises bees and makes honey. And he came around and said, I'd like to copyright the name for the honey. Well, of course, that was the wrong word to use. You don't copyright a name. But the point is that there's language out there, copyright, trademarks, patents, intellectual property, that people use, and they're kind of not quite sure why they use them or where they really fit in. So my job for the next 20 minutes is just to tell you something about the language that's being used in intellectual property. It used to be called industrial property, and that wasn't very classy or keen. So somebody changed it to intellectual property, and that sort of elevated everybody in the business a couple of notches. Okay, now the first piece of intellectual property that's supposed to work is this. Does it work? No. I did, I pressed that. I did already. Okay. What is IP, commonly called IP, intellectual property? What kind of types and tips and strategies and resources do we use and so on? So that's going to be mine. Now with that. Okay, what am I doing wrong? And what are you doing right?
This one to go next.
That's next.
Yep.
Okay. Yay! Okay. Intellectual property is something you can't feel, see, touch, smell, and what have you. Unlike your car, or unlike that 10 acres that you own and growing grapes in, or whatever. It's ideas, marketing ideas, scientific ideas, ideas about computer programs and that sort of thing. It's ideas. And somehow we capture that into documents, patents, trademark registrations, that sort of thing. And we capture that into laws, and that's why you have lawyers. So to sort of tell you about the framework of the laws in which we work. And Canada has laws that are quite similar, but not identical to the US or Europe or other places where you may be doing business. So we have a generally understood framework of laws captured into some of these concepts. Okay. A business asset. You know, what's a patent? I'll give you the technical legal definition and then we'll move on. A patent is a scientific invention that's new and useful, and it describes that in what's called a claim, which circumscribes, fancy legal word, about what your idea is, your scientific idea is, that's new and different from anything that's ever happened before. And if it's properly drafted by somebody competent to do that, do not try this yourself. Then for 20 years, from the time you file an application for a patent, you are the person entitled to use that invention. You're the person that's entitled to sell it, to license it, to market products. What it's often used for, though, is not quite in that technical sense. It's used as a marketing scheme. I've got an invention, I've got a patent for that, and you better buy my product because it's wonderful. It's a way of saying how wonderful it is that the government has recognized this as being something new and different and so on. So it becomes a marketing tool, and it becomes a sort of game almost, with some people saying, well, I've got 10 patents that cover how to make honey. Oh, well, the other fellow says, I have 12 patents how to make honey, so let's, swap around and see who owes who what about what money and so on. It becomes a negotiating tool or a business chip for trading. Okay. Why do you care about what the other guy's doing? Obviously, you have to figure out that if you're going to go into a business, for instance, if you're selling a medical device, you better find out if somebody else has got a patent or some other kind of intellectual property protection that covers that medical device. There are ways of searching for them. They're not always accurate, they're not always complete. The answer you're going to get is maybe. Okay, I know that's not a very comfortable answer. That's the sort of answer you're going to get. But if you want to go into business making something, or making a process to make something, you better find out what the other people have out there that you might trip up against. Okay. Types of IP. Here are the words you use. Trademark. What's a trademark? A trademark is something like Coca-Cola. Trademark is something like the Nike swoop. You've seen that on t-shirts and running shoes and so on. So it's a word, it's a symbol, combination of words and symbols that are used to identify the source of a product. So if you buy a pair of running shoes and they've got a swoop on it, you know it's Nike shoes. If it's got 3 stripes, you know it's Adidas shoes. These are trademarks that help you identify whose product it is. And if you want to get into a business and you want to market something and you want to make your product distinguishable from somebody else's, you could well think of a name, think of a symbol or both, that will allow you to sell, in your case, honey, let's say, your honey that makes it different from somebody else's honey because it's got this wonderful Ajax word or some other symbol on it. So that's a trademark. And a trademark, you can just get it by using it. You don't have to do anything more than use it. You can register it. We'll be hearing more about registering a trademark too. And that gives you rights that are kind of solidified, proof of the registration and so on. Patents. I touch a little bit on patents, but it relates to scientific ideas. So if you've got a new device, if you've got a new way of making a chemical, if you've got a new chemical, a patent will apply to that. It's scientific, it has to be new, it has to be useful, it can't be just sitting there on the floor, and it has to be inventive. And lawyers make a lot of money trying to distinguish what's inventive from what's not inventive. Okay. And that's discussion for a lot of other discussion and years of discussion. Copyright. Copyright began by being something related to a song, a book, a poem, a play, even a dance. But it's expanded well beyond that. For instance, computer programs, copyright protects that sort of thing. So it has to do with artistic, and computer programs may not quite be artistic, but they're in that area. It covers something that relates to the arts or coming out of what they call an original expression of artistic merit. Copyright. Trade secrets. A secret is only good for so long as it's secret. Okay, that's sort of saying the obvious. But for instance, what's the formula for Coca-Cola? You've bought Coca-Cola, and there's Pepsi-Cola. It tastes a little different. There's the cola that Loblaws puts out or other people put out, and it tastes a little different. So Coca-Cola's got this very special way that's not telling anybody. Those of you that drink chartreuse, apparently it's that liqueur that's known only to 3 monks in some cave in France somewhere, or what have you. As long as it's kept a secret, that's okay. There was a big court fight about where gold is found in northern Ontario. The case was called Lac and Corona. And of course, one fellow in a bar told the other guy, I think I know where there's some gold. And he said, but that was a secret. You're not supposed to tell anybody. Told everybody, and there you go. So a trade secret is a good thing, but only so long as you keep it secret. And if you have to tell somebody else, they promise to keep it secret too. Okay? I tell you who's a gossip in town, but you got to keep it secret, that sort of thing. All right. And then the last thing is industrial designs. There's not a lot of activity in industrial designs, but it has to do with making a thing look pretty or something on a thing that looks pretty. Think about the plates that you got for your wedding present. You know, they have a certain design on them and that sort of thing. It has to do with those designs or the shape of something. Think of the Apple iPhone. Think about the sort of smooth shape it has. It has to do not with science, it has to do with appearance. And so this is a sort of common basket, if you like, of intellectual property. So you can't copyright a name, you trademark a name. You can't copyright an idea, you patent it. You don't get a trademark that applies to clothing or something like that because that's an industrial design. All right, trademarks. Quick run through. It's a sign. I'm going to read it from over here. Mixture of signs and uses and so on. And you have to use it, okay? Until 3 months ago. I'm not going to get into that, where the Europeans have got us suckered on that. But essentially, a trademark is something that's acquired by using it. So if you open up a pub like the Three Daves, like we were talking about earlier, 3 people around here are called Dave and they're all going to run a pub. That's a trademark as long as they run a pub and call it by that. They can register it and that improves their rights. Here's some ideas about that. Just coined words like Kodak or Kleenex or Costco. Dictionary words that kind of doesn't suggest anything. Apple, nothing to do with computers. Roots, nothing to do with shoes and so on. And then the suggestive stuff like chapters for books, unique logos. They say personal names are not good. Well, you know, McDonald's, well, for crying out, Ford. You know, personal names do get to be trademarks. It's a little tougher to have them there. Okay. Planning on trademarks. If you're going to have trademarks, if you're going to sell in Quebec, for instance, make sure that what you're calling something doesn't translate into bad French. There's a few people that tried to do some products that translated very badly into French, and they were insulting words. There's a brand of a Hyundai car that is a very nasty word in Portuguese, and so on. So kind of look around if you're trying to think of a name. There is a registration database. You can access it. You can look at it. You can see who's already got a trademark registered. Again, there are professional people who do this. I highly recommend that you use one. It's kind of like taking out your own appendix. I think you can do it, but it's not what you should do. Okay, patent. Again, the new and useful inventions. It's 20 years from the time you file it. You have to tell people what your invention is, so it's different from a trade secret. You can't conceal what your discovery is, what your scientific advance is. The whole deal of a patent is, we'll give you a 20-year exclusive on this, provided you tell everybody what it is in a clear language so that they know how to do it themselves, people who are skilled in the area. You can do prior art search. You can do searches to see if somebody's already got a patent. You can do searches to see if what you've got is really different from what's out there. You'll be surprised. You know, you'll think of stuff, and then you'll see that somebody already did that 50 years ago. You know, you can do this from online searches. Again, qualified patent agents have got vast databases and searches. They can do that for you and tell you what's already out there and whether yours is really different and so on. If you're in a business with partners and you always collaborate in making this particular invention, it's important to name everybody who collaborated in doing the invention. So if you and three Daves and Dave and Dave and Dave all collaborated in making a new spigot for the beer in the pub, they all got to be on the patent application if they collaborate. Just in the last little while, clean, green stuff gets a fast track preference. That's more for show than for reality. Okay, popular misconceptions. Once you have a patent, that doesn't give you an automatic right to use the invention described in your patent. People are surprised by that. But often your patent is slightly different, an improvement on or a variation of something that exists out there. So you've got to look and see if other people have patents as well that nonetheless cover or deal with the same subject matter that you intend to have in your business. So it's not an automatic get out of jail card free. It's just a start on that. The patent isn't enforced by itself. If you see somebody that's using your invention and you want to stop them and they don't do it voluntarily, short of sending somebody in a black Cadillac and a couple of baseball bats around, you got to hire a lawyer. And patent lawsuits, and that's what I did as a judge. I dealt with a lot of patent lawsuits. Lawyers will typically cost you, how many are ready for it now? $1 million. Okay, so you better be sure about suing somebody on a patent before you go ahead and do that, because it's not a game for sissies or for amateurs or for people who aren't well funded. Copyright. Copyright is easy. You don't register it, you just have it. If you write down a computer program, you're the owner of that, you're the author of that, and it's yours for your life, for your lifetime, and 50 years, soon to be 70 if Donald Trump signs the right document, 70 years after you die, so you can be glad that your children, your grandchildren, and your grandchildren's grandchildren can benefit from this wonderful computer program that you wrote. There is a registration system. It's stupid. It doesn't work, okay? In the US, they have a registration system that's far better, but we in Canada really don't have one. What I suggest is if you do something, like create a song or develop a computer program, do the old trick. Put it in, copy it out, put it in an envelope, mail it to yourself, seal up the envelope, sign it on the back, and make sure nobody touches it. And that'll at least serve as some proof that you did something at some time, okay? And again, when it comes to copyright, if you see somebody else has got the same computer program, or more likely using bits of your computer program, you can license them and try to make a deal with them. If you have to sue them, what's the number? Not as big as patents, but half as big. But it's not a game for sissies, it's big bucks. If you see Mercedes driving around, or Bimmers, chances are it's an IP lawyer that's driving it, so you get some idea of what's going on. Okay. Copyright tips. In the US, this is where the US law really is different than ours. They want you to put your name and the year that you made the program and the word copyright, or you've seen this, see in a circle around it. You've seen that in, say, books that you've read, or pieces of music, you see that at the top, or even computer programs when they come up on the screen, you'll see John Smith, copyright 2018. Not a bad idea. Not a bad idea, because in the US they ask that you do that. If you're a Canadian or somebody like that, that's a good idea. If you develop something but you're employed, you're an employee of somebody else, unless your employment agreement is very clear about who owns what, it's your employer. So if you're an employee of IBM and you develop a computer program, it's IBM's, okay? You can license somebody, you can permit somebody to do that. Infringement means that somebody else is taking some of your copyright material. Hard to prove, hard to find out. It's a tough game. I mean, I've had cases where a guy comes in and it says, okay, they've ripped off my song. Well, there's the song, yep, and there, it's on the, it's on YouTube or whatever, and that's the song. Well, how do you know you developed that song? Well, I sing it in the shower all the time. Oh, and how did they get a hold of it? They must have bugged the shower. Well, it's about time for a court to take a break right about now, and maybe you ought to too. Okay, so it's a little tough on that. Trade secrets. We talked a little bit of trade secrets again. Confidential. If you have a special way of making a particular kind of wine, how do you macerate the grapes and throw in a certain yeast at a certain point and so on? And if you keep it secret, then it's yours forever, and if people like the wine. But if you hire employees who are doing this for you, which you probably will be, you better make sure that you've got some kind of employment agreement that says that they've got to respect your secrets. Many employment agreements have clauses, paragraphs in them that say, it's my stuff and you shall not tell anybody, and if you tell anybody, Black Cadillac, baseball bats, and so on will visit you in the night, and if not, at least some lawyer. Okay. Here are some tips about trade secrets. Basically, keep it secret. Industrial design. As I said, industrial design applies to the shape of something or the appearance of something or something placed on something like a lovely flower or something like that. Not many people bother with it. You see it now and again. It's if you're in the business of making dinnerware or something like that, then it's important to. But otherwise, Here are some tips on industrial design. They have to be new. It has to be different from what somebody else has got before. You can search what they've got again. And there's no such thing as an industrial design agent, but a patent agent will do that for you. A trademark agent will do that for you. Okay, IP strategy. How am I going to do it? I've got this new invention. I've got a patent application pending. Do I license somebody and try to make 5% of what they sell as income? A lot of people will try to do a licensing for it. Do I sell it to big mega corporation and hope that they'll pay me $1 billion? Good luck. But then that's another way of exploiting it. Or, as I say, try to keep it to yourself and hire a lawyer, and $1 million later maybe you'll win. I don't know. Here's a lovely chart. I hope you understand it. I didn't draft it, and I don't understand it, okay? But I'm sure you do, and you've gone right to the heart of it. And that's it for me, okay? The Intellectual Property Institute, of which I'm a member, was a past president, and many other intellectual property lawyers, agents in Canada are members. There's their address. They have a good website. If you want to visit the website and you're saying, I really didn't understand this, or what's that about, go to their website. They'll tell you stuff. They have a list of people who are agents that you can contact them and see them. You've got 2 people here tonight who have shown a special interest coming down here, and I congratulate them. I think it's a good thing that they're coming down here and trying to make contact with you and trying to understand with you how this whole process works. So the Institute's a heck of a good thing. There's some information about that. And for that, I'm done, and it's over to you. And that one's advanced on link.
Okay.
It's non-intuitive.
That's the magic button?
That's the one I screwed up, yeah.
Thank you, Roger.
Can you see all right?
Yeah, I'm good. So, hi, everybody. I'm going to talk a little bit about most of the same things that Mr. Hughes talked about, but I'm going to try and do it a little bit more from the perspective of actual products and commercializing them. And,
Yep,
okay, the forward is really backward?
yeah, it's not intuitive.
Oh, let me fix that. Okay. I'd first of all like to reminisce a bit with you. In my first year of law school, I took criminal law, and when we were going to be having our first midterm, we walked into the testing area. Our prof was there, and he said, well, I've taught you some steps. Now let's see if you can dance. And then he handed out the exam. And there was a complicated fact situation, and the question was basically advise your client what to do. So, when we're looking at it and reading it, you think, okay, well, I got to root around in the criminal code, and I've got to figure out what criminal charges might apply. And I got to rack my brains and try and remember some cases that I read and see how judges interpreted those charges and fact situations in other cases. And then I have to try and put all of that together and kind of predict what might happen to my client on the exam. And then I have to come up with advice. And that's pretty similar to what we do when we try to come up with a strategy for protecting your intellectual property. Typically, an entrepreneur wants to protect, their idea, the way they do business. You want to protect it from everybody in any way for as long as you want to do business, and you basically want world domination. Unfortunately, intellectual property law won't let you protect an idea in the abstract. The best we can do is go through these types of protections and sort of mix and match and try and come up with the ones that will be relevant to whatever your business or service is. And we've listed up there trade secrets, trademarks, patents, copyrights, plant breeders' rights, integrated circuit topographies, and geographical indications. And some of these are only relevant to sort of some businesses. Others, like trademarks, might have application to just about everybody. Yes? No? Okay, so I'm going to talk a little bit about trademarks. As Mr. Hughes mentioned, a trademark can be a word or a slogan, a combination of words, maybe some graphics. And these are some examples of registered trademarks that are up there. But these are situations where people have gotten a little bit creative. You'll see that there's the artwork for a packet of bicycle playing cards. So you can protect, the artwork on packaging. First of all, that artwork was somebody's artistic work, so there's some copyright in it. But additionally, if you use it as a trademark, you distinguish the source of your products, and it becomes recognized as an indicator of source, then you can protect it as a trademark as well, and you can register it. You see a swatch of plaid up there. That's, although it's not in color, the Burberry plaid. And the Burberry plaid is a trademark, not just the pattern on the clothing, but they've put a lot of enforcement and advertising and whatnot into policing it so that they're the only source, and that beige and black plaid is recognized. You see that coat and it's a Burberry coat. So it's a trademark. It's also possible to use colors to protect colors as trademarks. And there's a couple of examples. There's a famous brand of snowmobile, and parts of the snowmobile are a certain color, and you can identify the snowmobile that way. If you think of Home Depot, they have protected the color orange as a trademark for their services. So basically, the orange on the staff aprons and things like that. There's a fishing rod up there on that illustration. The color pink has been registered as a trademark for fishing rods, presumably marketed to women, I don't know. And then it's also possible to, if you package your product in a unique and recognizable way, it's possible to protect the packaging as well. And you'll see out there's sort of the iconic Coke bottle. That's now a registered trademark. So, it's taken a long time to build up recognition, but that is possible. And so long as they keep using that trademark, they can perpetually have a monopoly in that. Similarly, you'll see a package up there for Ferrero Rocher candy. And the trademark is the entire package, so the clear plastic box, and inside it, the little gold wrapped balls. So that's a registered trademark. Apart from packaging, you can also get three-dimensional trademarks. And the examples up there, I've got the Easy button that Staples uses. It's been part of their marketing campaign and commercials. And they also sell the three-dimensional Easy button as a novelty item. So that's a three-dimensional trademark. And then in the top left-hand corner, there's an example of a registered trademark, and the subject of that trademark is the interior design of, I think that was a restaurant or something. So if you have a specific look, and all your restaurants have the same look, then that's something that you can protect as a registered trademark once it becomes, comes to distinguish you. So those are all visible trademarks, and you can see you can get pretty creative in protecting different aspects. You can sort of create a hook. Now, yeah.
Are we allowed to ask questions?
Sure.
Sure.
It's very quick. You keep saying, does it have to be familiar in the public domain before you trademark it? Or can you go into it with a Coke bottle trademark and say, this is a trademark?
Well, because the Coke bottle is out there, you can't get a Coke bottle. But
Right.
you could
My
choose
new
something.
bottle.
You can choose something new, and by adopting it and using it in the marketplace, you start to build up trademark rights gradually. As it gets recognized, you've advertised, you've sold product, people start, recognizing it maybe in your local area, then you will have trademark rights at common law for as far as your reputation extends. Now, if, there's somebody out in BC comes back to Niagara Falls to visit, and they see your trademark here, and they think, oh, that's a really cool product, and it's only here, they can go back out to BC and set up with the same trademark, and if you don't have a reputation out there, there's nothing you can do about it. So you register your trademark, which is under the Trademarks Act, which is federal law, and then you get the right to prevent other people from using your trademark or something confusingly similar throughout the country.
Can I add a little spin on that? As of 3 months ago, Canada joined a sort of European-based international trademark situation where you can actually file and register a trademark without having used it. But you got 3 years to use it after registration, otherwise it goes out. So there is a way, brand new way. We're not quite sure the limits or just how far it goes. But there is a way of kind of jumping in with something that you haven't yet used. But you know what they say about the lead dog in a husky's sled? Eskimos, the lead dog gets its nose frozen, so we all know what's going on.
Okay, actually, in the same recent legislation that Mr. Hughes was talking about, the definition of trademarks that are protectable in Canada has been broadened, and now you can get what are known as sensory trademarks. So that is sounds, tastes, textures, smells. So long as these things are distinctive and can, in the minds of the public, associate that product with you as its source, you can protect them as a trademark. And there's a few examples up here. One of them, there's a sound mark. There's a sort of a 5-tone audio progression that you hear when you set up your computer. So that Intel inside. That's a trademark. The Toys R Us song. I don't want to grow up, I'm a Toys R Us kid. Trademark for retail sales. The MGM lion that roars at the start of every movie, that's a registered trademark for that production company for the movies. But you can also get some pretty weird things. A peppermint scent has been protected, I believe, in the States for gloves. People have protected a grape scent for industrial lubricants. So, you squirt the lubricant around, and if it's the grape-smelling one, you know where it came from. And then another interesting trademark, It's a combination of the sound of thunder and rain and strobe lights that imitate lighting. And that's a trademark for a misting apparatus that's used in grocery stores in vegetable displays. So basically, if you can come up with a hook, chances are we can find a way to trademark it for you. So we've already sort of talked about this, when does what you're doing become a trademark? And it becomes a trademark when you actually use it. You put it on your goods themselves, or you put it on tags, people see it at the point of sale. For services, you display the trademark when you're performing the services. That might be the sign over your restaurant, could be your website, things like that. Just a quickie, what's not a trademark? Now, the registration of a corporate name or the registration of your business name does not grant you the right to use that name as a trademark. The real purpose for having a registry of business names or corporate names is so that the public can go and figure out who's behind a particular name, so if they have to sue you, they get the right legal entity. Now, if you use your corporate name or your business name as a trademark, meaning you're using it to identify you as the source of products or services, then your name can be a trademark, and there's just an overlap then between your corporate name and your trademark. Examples of that, you just think about like Old Navy is a business name, but it's also a trademark for retail sale of clothing. Levi Strauss & Co. That's their corporate name, but if you take a look at the tags on the back of a pair of Levi's, you're going to see it used as a trademark as well. Same sort of deal with domain names. I mean, basically a domain name is just an address that you use to access a website. But if you're promoting and using that domain name as a trademark, then it can end up being a trademark as well as just being a domain name. And you think of like Amazon.ca. I mean, they advertise like crazy, and they're using it as a trademark as well as just a domain name. So when you're choosing your trademark, you gotta pick a mark that's available. So first of all, how does your trademark relate to your goods or services? Is your trademark the name, or is the word you want to trademark the name of a product? For example, Apple. You can't trademark the word Apple if you're selling apples. You can trademark it for computers. It has nothing to do with apples. Similarly, you can't register anything that's clearly descriptive. So you can't register red for apples, because that's got to be available for everybody who sells red apples. You want to stay away from common surnames. It's possible to register a surname if you've used it a long time and put a whole lot of marketing into it, and it becomes recognized as a trademark in addition to somebody's name. For example, Whitney Houston is a registered trademark. And I know, because I had to file a whole lot of affidavit evidence to try and prove that it had a meaning other than just Whitney Houston. And then the other thing is, you want to make sure that your trademark is not confusingly similar with somebody else's. Because there's no point in putting time and money and packaging and signage into something if people are going to confuse it with your competitor. Get something different, get something that stands out. And you've got to think about confusion in terms of the mark itself and also how it relates to the business and the channels of trade. You want to make sure that the trademark doesn't look the same, it doesn't sound the same, and it doesn't have the same meaning. So there's a couple of examples up there. You'll see Google, G-U-G-A-L. That would be confusingly similar with the word Google for computer search engine stuff. It doesn't look the same, but it sounds the same. Or tsunami and hurricane might be confusingly similar if they were both being used for the same product. Again, no similarity of looks or sound, but the meaning's the same. Okay, I'm going to jump away to something that's not a trademark. Oh, sorry, yeah.
I've heard that trademark protection is limited to the industry that you operate within. Is that true?
It can be. When you're looking at whether or not two trademarks are confusingly similar, you're looking at how close the marks are and then how similar the businesses are. So if you've got a trademark that's completely unlike anybody else's, maybe Xerox, then they could probably stop you from bringing out, Xerox Cola or something, because they're the only one in the area. But if there are quite a few marks out there and, some sort of similar businesses, then, you may be able to register a mark in a particular business, but other people can have it for a different business. An example of that is like Apple Computers and Apple Auto Glass. The two coexist. The market's not the same, the purchasers are not the same, so there's no confusion there.
And Apple Records. Beatles had Apple Records.
Yeah.
Yeah,
Yeah.
If it's possible, guys, could we keep all the questions till the end just for the live feed, I hope we can hear the questions.
Okay, I'm just going to spend a couple seconds on geographical indications, or GIs. They used to be called appellations of origin. Now, these are not trademarks, but they kind of interfere with trademarking a bit. A geographical indication is a sign that's applied to products that come from a particular region, and there's some characteristics or qualities about them that are identified with that region. And you'll see some examples up there. Champagne, lots of people make bubbly stuff, but unless it's made in the Champagne region in France, it's not champagne. Prosciutto de Parma, Korean ginseng, those types of things. In order to register or protect a geographical indication, you have to be an appropriate authority. So this is not something that people individually use to protect their own business. It's something that a trade organization or a region would use to collectively protect the producers of a product. Some recently granted ones are Niagara Peninsula for wines or Beansville Bench for wines, on the basis that there's a recognizable area with the products that have a recognizable characteristic. Individuals cannot use the geographical indications without authorization. If you're making prosciutto, you can't call it prosciutto de Parme if you're made it and are selling it in Canada, because that term is reserved to somebody else. So basically just watch out for them, because they're out there. They can get in your way if you're looking to trademark. But if you're part of a trade organization in the agricultural field, it might be useful for you to think about protecting one of these. Okay, we've already talked about copyright, and I'm going to just sort of skip ahead a little bit and get on to industrial designs. Industrial designs protect the visual appearance of items. So it could be furniture, automobiles, wallpaper, clothing. The protection is for a period of at least 10 years and up to 15, and that's a recent development. And you have to keep your industrial or your design confidential before you file an industrial design application. You get a 1-year grace period between making it public and filing the application, but beyond that you can't protect it. So these are some examples of things that have been protected as industrial designs. So you'll see that there is like a shoe sole, a particular pattern on a shoe sole, the shape of a desk chair, a calculator or a cell phone, the look of the case. It's also possible to protect the layout of the user interface, sort of like the home page when you turn your phone on. Just the appearance of that has been protected as an industrial design as well. No functionality, just the appearance. But industrial designs are useful to mix and match with other kinds of protection. The example that I have up here is a situation where they've mixed and matched, and they've used industrial design protection to protect the box, the packaging of those candies. So when you think about it, you file an industrial design application, you have protection for 10 to 15 years. If you were trying to protect that as a trademark, at least historically, you would have to be able to demonstrate that the look of that package can function as a trademark. It can distinguish your products from other products. And usually it would take a fair bit of time to build up recognition in the marketplace. So if you tag team with industrial design and trademarks, you can protect it right away with the industrial design, and by the time the industrial design expires, you've been in the marketplace a long time, and you then just carry on with your trademark that you can protect indefinitely. A similar thing also works with patents. You may have you may be applying for a patent, and somewhere in the patent application process, which takes 3 years, 4 years, depends. And you may not have your patent in place yet. Eventually, you may get a patent, and it may protect some functional aspect. For example, if you had a toaster, you might have a new mechanism to prevent the bread from burning or something. But you might also want to hit the market with the really cool look of your toaster because you made it look like a spaceship or something. It looks all sleek and cool. I mean, people buy products because they look good. So, lock up the visual appearance of it. And you may still be chugging along with your patent applications and whatnot, but you can use multiple types of intellectual property in tandem. Industrial designs are cheap, and you get them quickly. So, you can tag team with some of these things. And, oops, I'm on the wrong button. Okay. One other thing I wanted to mention are plant breeders' rights. Now, this is only going to be relevant to you, I think, if you're in the agricultural field. Plant breeders' rights are an exclusive protection that you can get if you have bred a new strain of a plant. No bacteria, fungus, or algae, but a plant. So your flowers, your tomato plants, whatnot. And if you have created something that's new, it's distinct from any other, similar, all the other tomato plants, for example. And you can identify particular characteristics that are different about yours than about the other plants, and that your plants are uniform and stable. So you've bred them for several generations, and those particular characteristics go from generation to generation, and it's stable. Then you can get exclusive rights in that propagating material. So if somebody wants to grow, your purple tomato, they have to come to you for the propagating material. And the other thing with plant breeders' rights is you also get to name it. And you can keep people from using the name of your variety. So a couple of examples of that. One of them is russet basin for potatoes, so nobody else can use that name, or sensation blueberries. And if you take a careful look at the Trademarks Register, you'll see that there are these denominations for plant breeders' rights, and they show up in the Trademarks database. So if somebody has, named their blueberry sensation, you're not going to be able to trademark your, pick your own blueberry field sensations. So it's just another thing that might be relevant to some people, might not be, but it just sort of keep that arrow in your quiver. It's something that might come in handy. So I've given you some examples of, the way other people have protected various products and services. Just keep in mind, mix and match, and, get creative. So now I'm going to turn it over.
Awesome, thank you, Valerie. Next up, we have Sean. Sean, you can just scroll through the next slide.
The arrow button.
Okay.
But
It's upside down.
It's not the one.
It's upside
It's
down.
not the one you think it's going to be. It's the backward.
There.
There we go.
All right. That works now. Okay, you have just heard from Justice
Valerie.
Hughes and Valerie about the IP rights, what that is, and how you get it, why you care about it, and how you use it. And so now I'm just going to add a few words on some of the IP issues that should be on your mind when you cross border, taking your business to the other side of the river. Okay, border crossing. And I guess for you guys, people in this room, it's really natural. You don't think about it twice. And for me, it's different. Each time I go across, I will stop saying, where are you going? What's the purpose? How long? And business or vacation. Or if it's a business, what's the nature of business? So I always be reminded that actually I'm crossing that border. And for you, maybe that's not the case. However, I think whenever you actually take your business to the other side of the border, whether it's something that's more visible, you open an office, or you hire someone, or you sell the products there, think what are some of the things I need to consider before I actually start doing it, and what are some of the impacts they might have. And then there are also something that's probably not so visible. Maybe for example, you just be on the phone with someone, your business partner in Niagara Falls, the other side of Niagara Falls, and they say, hey, why don't we put our teams together, we develop the product. Or you may just make a phone call, say, hey, I have this product, and can you be my US distributor, and let's start working together, making some money. That sort of thing. And so there are lots of things that can happen to us a little bit away from border, and probably we don't have that much interaction with people in the US, but here things might be slightly different. So when you cross the border, what do you do? And here is just a more visual representation of let me see this. Oh, okay, there. Okay, doesn't work. So on the Canadian side, you have a company C, and you have a business there, you have your team, and the other side, US side, you have company A for American, and you have their team, and you may set up your branch office in the US side, and you may even hire some people locally, and or maybe you send someone there working from the US. Or you may do some deals with people. For example, you sell products to your US customer, or you, as I mentioned, you may have these joint efforts. So here, just in case we want to go back and make a reference to this, I just put some numbers to this, and here, the numbers. So if we want to make a reference. Okay, now you cross border. What can be different? Well, we know that gas are cheaper, and clothes are cheaper, everything's cheaper. But other than that, a lot. Many, many things. And one of the things is with IP. With IP, they are territorial. And you have heard that, for IP, you have to get registered, etc. Where do you register? Of course, you register with the government. You register with the Canadian government, you get protection in Canada. You register with the US government, you get protection in the US. If you don't register with the US government, no protection. It's as simple as that. Well, but that's probably a little bit exaggeration. Like for copyright, that's an exception. You don't need the registration, as Justice Hughes mentioned earlier. But in any case, for patent, you do need the registration. If you don't, there's no protection whatsoever. And what's worse, if you have a patent in Canada, because you have to tell people how to make your product, describe it in all the kinds of detail, very, very detailed in your patent application, how that product is made, how it works, how you put them together. People can download that application from that website, canada.ca/patent, find it, and they know how to make it. Because we didn't do that, have a registration in the US, people can just copy it, do it exactly as yours. And you can say, oh, that's infringement. No, because you don't have any rights to begin with in the US. No registration, no rights. So, and also the landscape of IP could be different. You could have your registration here, for example, you have trademark registered here, but not in the US, and vice versa. So you may face something that you haven't seen that in Canada, but that's in the US, you cannot do it. And then, of course, although we are similar in many ways, language, culture, etc., and even laws, but there are still differences. And for example, if you do a deal with a US partner, you could develop something and you say, okay, let's just own this piece of IP jointly. And what that means in Canada and what that means in the US are different. And I'm going to use some examples to illustrate how that can be different and actually how you could get a surprise and sometimes not very pleasant. So, what do you do when you're in the US? Just make sure that you recognize this difference and you make sure that your business and in particular your business practice are set up properly, following the laws in the US. Do all the things that you need to do as if you are just a US company. So some of the things, if you don't do, for example, I just mentioned, people could just freely copy your patent and make the same product in the US. No problem at all. They're entitled to do that because you have no protection and you already taught everyone how to do it. And then we can reverse that situation. Someone, they may have no registration, for example, no trademark registration or no patents filed in Canada, but they do have that in the US. So even though you're doing the same thing in Canada for years without any problem because there's no trademark registration preventing you from doing that, or there's no patent in Canada covering your product, so you're not infringing anyone's rights. But in the US, suddenly you may find, okay, someone actually has a trademark registered, and your mark is what is we often call confusingly similar to their mark. And suddenly people will want to say they want to stop you, they want to sue you for that. Or your product may actually fall within the scope of some people's patent protection. They want to sue you, want to stop you. And this one, although I just put US employee, actually it applies to anyone. If you don't have that in Canada, then some of the IPs may not belong to you, may belong to your employee in particular, if it's a patent, if it's an invention. For the invention, you may later on go to a court argue that, well, I had this employee just to do this development, and his only job is to develop this technology, therefore that belongs to me, but that's one extra hurdle you have to get through. But you may win, and you may lose in the court battle. And that employee could actually, what we call assign or transfer or license that rights to a competitor. So one day when you say, okay, I have a patent, I want to sue that competitor, then you suddenly find out that your employee gave that rights to a competitor. There's no case for you anymore. And in Canada, the thing is that there's a little bit restrictive in terms of how employee, even if they own that rights, how they can assign that, how they can license that. But in the US, it's much easier to do that. So there are more things that can be different, and these slides will be focused on some of these deals you want to do with make sure that you look at all your agreements, and they are going to take care of the situation in the US. So the agreement might be good for Canada. And you have done that many, many times, no problem, you are well protected. But in the US, you may not be. And also, sometimes you do the same deal over and over again, and your IP in Canada, if you follow the right advice, is protected. But if you follow the same advice that's good for Canada, it might not be good for the US. And you may suddenly find out that I have a patent application filed in the US and in Canada. And because of one thing I didn't do right, my US patent is not good, even though my Canadian patent is still good. I did the same thing. And here is one example. Here's one example. You just heard that for patent there is this 1 year grace period, 12 months is such a public disclosure, and if you did that, you have to file your patent application within a year, so in order to get protection. And in the US, there's another thing called on-sale bar. If you sell your product in a commercial sale, then that day will start a clock. Within a year, you must have your US patent filed. If you don't do that, too bad, it's too late. It's too late, and your US patent is no longer valid. So even though you could go through all the process, you get patent granted, you have that piece of paper, it just, when you go to court, the judge will tell you it's no good. So we have many situations like that, and even though that sale is not public, you did all the right thing, you say, okay, I just want to make this sale and it's confidential, you don't disclose this to anybody. It's you, just you, the customer. Only you can use it, you cannot disclose it. You have all these non-disclosure agreements, they are all drafted well for Canada and you signed and everything's done. But as long as there is a commercial sale, that is not good. And now it's even getting worse. A few years back, it's only that sale in the US that will invalidate that US patent. And now, after change, it's anywhere. So if you want to have a US patent, make sure that you do have your US patent filed quickly, early. And this one, that's also something that sometimes comes as a surprise to us. Suppose you work with a partner and you develop technology and it's really just a handshake, or maybe even a little bit better, you have an agreement. But as to who owns the IP, you just simply say, okay, it's going to be owned by both parties. So any party can freely use it, and that's it. That sounds fair, that sounds good, and very simple. Except if you find the infringer in the US, it may not be good enough. You may have to go back to your partner and ask your partner to be part of, to be a party to that lawsuit. Otherwise, your case will be dismissed. And in the worst scenario, you may, already broke up that relationship with your partner for years, and later on, you want to sue someone, and you want to get that partner back with you, and your partner will say, okay, I think there's an opportunity for me. Why? Because they also own that piece of IP. They just suddenly found a windfall. Okay, you, the infringer, or not the defendant, I can just sell my IP to you, or I give you a license, in which case, Either you're suing a co-owner, in which case you don't have any case, or you're suing a licensee, and they already have the right to do it. So there might be some issues as to whether that cover things in the past, but at least you won't be able to stop that company or doing anything in the future, and which is what may concern you most, because you are going to lose your market share in the US. So, what do you do? Before you start that relationship with a US partner, make sure you say in your agreement, in addition to how you own this IP, also who's going to get patent for the IP, how we are going to sue, if there's any infringer, and whether the other party must join you in that lawsuit. And if there's any negotiation with that defendant, that the infringer, can one party make a decision to negotiate and settle? No, because if that's the case, you won't have any case. Your case will be dismissed. So all of this need to be negotiate with other party and written down in that agreement. So at least that way, you know, if something bad happens, what's going to be the outcome. And here I'm just going to also mention this thing, and this is very something that sometimes can be a surprise. I don't know here, do we have anyone here in the software business? Okay. It's just I do lots of work with high-tech companies, and many of them develop software. We all know Canada has this particular interest in protecting our cultural industry, and that's when you talk about culture, it's more than just publishing books or magazines or broadcasting, and video product is one of them. If anyone that is a foreigner, U.S. Investor included, want to make an investment in the culture industry, then that investment will be subject to government review under the Investment Canada Act, and also will be subject to its approval if it reaches the threshold. For the culture industry, that threshold happens to be so low. It's only 5 million in assets. So if you control that assets, you only need to have 2.5 million to control it. And what's worse is the act deems that if it's 1/3 of that control, then you have to prove to the government that 1/3 actually is not controlling. So if you get some investment from the US, then that could be something surprising you. And this is just using an example to show that when you do business with other side, and often there are many, many things that could surprise you. So to conclude, really, when you go to the US, one thing is you always keep in mind that the IP landscape is going to be different, and how the IP law is going to work is going to be different, and your protection might be different. And in order to get protection, first is always do as a US company would do, you make sure that your IP is filed in the US, is registered in the US, and do that as soon as possible. And when you go to the US, and just as you would do in Canada, make sure that you're not going to get into trouble in IP that is being sued by other people, and get a clearance first. Do this FTO, that's called, it's a freedom to operate, so you're not infringing anyone's IP rights. And if you have an agreement, make sure that they're reviewed and possibly redrafted just to cover the US situation, and in particular there, if you are going to work with your US partner, make sure that your IP, if you are going to own the IP jointly, this arrangement is carefully considered and drafted, so we're not going to have any surprises. So that's about it, and obviously we can only cover this much, so
Are we
most
open
likely
to
it's
the
going to
floor
be
now?
your questions, I think, probably going to be more interesting.
Thank you, Sean. Thank you guys for your patience and listening to the presentation. So, yeah, now we will open up the floor to some questions, and I believe the microphone will be passed around to each person.
Slapped around the head here for asking.
Okay, I do have a question. I've been involved in a lot of IP issues. And one of the things I always struggle with, although sometimes it seems like I know it and I don't, is when, the lawyers say, make sure you use, there's the R, there's the C, and there's the TM. And I always forget which I should be using, which is legal to use, which I can't be using, which I must use. Is there like a general rule for those three?
Well, for trademarks, your choices are the, For trademarks, your choices are the TM and the R. So anything that you are asserting is your trademark, even if you haven't registered it, you stick the TM notice on it. Once you have a registered trademark, then you switch from the TM to the R in a circle. And the C in a circle is just for copyright. You might see a D in a circle sometimes. That's a registered design, industrial design. What else might you see? You might see an MC if you're near Quebec, and that's the French version of trademark, marque de commerce, MC. And marque déposée is registered trademark in French, MD. Did that confuse things well?
No, that's actually very good.
Okay.
I don't need a copy.
Sorry.
But for the C, do I have to have registered as a copyright? Do you see I can use that anytime to assert my copyright? All right. Thank you.
So I work at the Niagara Falls Small Business Enterprise Center, and I work with lots of traditional Main Street small businesses, and many of them, when they're just setting up, seem to be very concerned about protecting their name and their brand. So for traditional small businesses, whether it be retail, contractors, professional services, would you have any suggestion as to when they should consider trademarking their name or logo? Should it be done at the very beginning, or is it something that they should invest in maybe after a few years of operation?
I'd say do your homework right off the bat. When you're choosing a name, you want to do the searches. You want to look at the Trademarks Register. You might want to do some searches on Google and see if there's any businesses that come up that aren't in the Trademarks Register, but the name's really close to yours. Do that before you decide on a name. You don't have to file your trademark application right away. I mean, you can get common law rights by using it, but you want to have that homework done so that you don't end up having to change your name because you didn't look and your competitor 2 towns over has a similar name. But as Justice Hughes mentioned, the Trademarks Act has changed recently, and you can get your trademark through to registration now in Canada even without using it.
Let me say there's kind of a structured way of doing it. Let's say you're Joe's Plumbing, okay? The first thing you should do is look at Google or the phone book or something to see if anybody else has Joe's Plumbing. And if they do, or they have Joseph's Plumbing, pick another name like Mr. Plumber. Think of something else, okay? If you're satisfied, Google, phone book, just asking around that nobody has anything like it, first thing you got to do is the Ontario government says, if you're carrying on business other than your personal name or the actual name of your company, you have to register that other name of the business. So if you're 1234 Ontario Limited, carrying on business as Joe's Plumbing, you have to register Joe's Plumbing as an Ontario business name. That doesn't give you IP rights, but it satisfies the Ontario government requirement. So if somebody wants to sue Joe's Plumbing, they can look up and say that's really 1234 Ontario Limited. So that's kind of a start. But if Joe's Plumbing seems to go along very well, trademark registrations of all these IP things that we have, it's the cheapest. And, it may be a few bucks well spent. I mean, what's your modest fee? $10, is it, for that? No, we're talking a couple of $1,000 or something like that, depending,
Just have a question. If you wanted to make a logo and you use something, an image that's public domain, how does that work? So if I create a logo with an image that is coming out of public domain, I think is it a certain year in which you can use the image without, because it wasn't copyrighted, can you then still, would you advise against it? If I were to make, yeah, you look at your face, yep. Look, yeah, I could see you, okay. Yeah.
First of all, any logo, any work of art, I mean, somebody at some point created it and they had copyright in it. Currently our copyright laws say that, copyright expires 50 years after the death of the author. Do you really want to go and try and figure out if they're alive or dead and whether it was 49 years ago and maybe the legislation's going to change? I wouldn't recommend, using stuff that's in the public domain or stuff you get off the internet. There are services out there that will design a logo just for you at a reasonable price. And if you do hire someone, make sure that they assign their copyright to you so that you are free to do what you want with it. You don't have to go back to them to get your logo changed or printed on your business cards or something. Start from scratch.
Yeah, I just want to add a few words. Oftentimes, because now with the internet, you can search, you can get lots of things for free. However, they're not really free. And in public domain, that's really some kind of legal term, meaning that they are really public, meaning someone created it, not just 50 years ago, and this author also died 50 years ago. So it's more than 50 years ago. Unless you actually can find something, this author says, hereby I donate this to the public, giving up all my rights. And that happens, but very, very rare. Sometimes you see, and more often you see is, hereby I grant anyone to use this for their personal purposes, for their personal use, but not for any commercial use. And in your situation, if you want this to be your trademark, that's obviously a commercial use. So there is one you freely get from the internet, and whether they are actually free, they're two different things.
I'm wondering about, for example, an online course or some copyrighted intellectual property that maybe is through a U.S. platform, but it's a Canadian creating it and providing it. The customers or students could be from anywhere. So it's kind of twofold as to how that works for copyright or needing to be aware. And if that person that's creating that is traveling while they're doing their work online, does that also have any implications for when they're creating their work and which country they're in? So it's kind of twofold.
Okay, copyright is actually one of the a special type of IP rights, at least to me, a patent lawyer. With copyrights, one of the things is once you create it, the rights automatically is there. So you don't have to do anything to register. And the other thing is that in the old days, we have the Berne Convention, and now we have WTO. So any member countries, they all agree that it doesn't matter where that right is created, if it's a citizen of that country, or it's a resident of that country, or if some work created and published in that country, then it gets protection in all the other member countries. So copyright is really a very special case, and in your situations, say a teacher created this in Canada, and then that's almost, just to make it simple, we could say it's automatically protected in all these member countries. Though the scope of protection and also how long it's protected, they are different from country to country. But you do have protection. And then this person, if they travel to the US or travel to Dubai or travel to Korea, anywhere and create that work, and they are all WTO countries, and then you always get the protection. It doesn't matter where, and then the minimum term is always also plus 50 years, and then once we go beyond that, then it can be complicated. If say you created this for a company, then where the company is, and etc. So, but in general, you don't have to worry about that. It's everywhere. Okay.
Yes, a question regarding business names. If I use my own name, which is fairly common, my name's Allison Smith. If I use A.E. Smith content in my business name, is that, like, would I have to register that? Is that protected? Like, where... Like, could anyone, if somebody else decided to start a business called A.E. Smith Content, what would be my, I guess, what should I do now is my question.
Oh, okay. Actually, there are two aspects to your question. One is, can I use it? And the second is, can anyone else use it? If they do I have any, can I do anything, any recourse against these other people? The first thing, can I use it? Yes, you can. As long as that is your name. But you cannot use someone else's name and register that. That's a different story, okay? So if it's your own name, then there's no problem. You can use it. Can you get protection? That's a different story. That's a different story. We have examples that personal name can be registered as trademarks and no one else can use it. Tim Hortons, McDonald's, and they're all personal names. However, you need to really use it for long and very extensively to get that reputation in order to tell people saying, well, it's not just a name anymore. And actually, that's my brand. And people always recognize, if I use that name, it comes back to my business. That's where the source is. So that is how you can eventually get the trademark protection. So you use it for 10 years, or maybe 5 years, or you do promotion very aggressively, and everyone knows about your business. Otherwise, if someone else happen to have the same name as yours, and there's really not much you can do about it. But if they don't have exactly the same name, then you can say, sorry, it's my name.
I'm not really worried. I just want to basically protect myself defensively, legally, and make sure I'm okay.
You hit on a very tricky little area, okay? If your name was Ronald McDonald and you had a hamburger stand, you're going to have trouble, okay? And if you wanted to open up a hamburger stand and say, I'm Ronald McDonald and I'm selling hamburgers, if the McDonald Corporation came after you, a court would probably say, yes, you can call yourself Ronald McDonald, but you've got to put all kinds of language in there to say, I am not the McDonald's company, and that sort of thing. If you have a common name, I'm Mary Smith, and I'm making hats, and somebody in the next town is also named Mary Smith and making hats, they can both call themselves Mary Smith's Hats. But usually, if it came to push and shove, you're going to have to do something to distinguish yourself each from the other. So I'm Mary Jane Smith, and I'm Smith with a S-M-Y-T-H-E, and they're S-M-I-T-H, or something like that. You're going to have to make an effort to distinguish you from somebody else. So yes, you can use your own name for what you're doing, obviously. But if it comes into the area of commerce, where somebody else is already in there, you're going to have to make some effort, I'm afraid, that your name doesn't become a free ride to use it. You're going to have to make some effort to distinguish the fact that you are not that other guy.
Yeah, actually, your question made me think of a question. I'm somebody who does a lot of workshops and educational things, and although I understand, I'm teaching people things, they're going to take my information, and that's the whole point. I want them to learn this information. But I've had some experiences where people take my original writings and my original thoughts, and then they use them for their teaching. So like, how it's kind of a slippery, I don't know, like how do I protect my workshops or my information from somebody else using it in their workshops? Or like,
you want copyright notices on everything because you have copyright in your expression of the ideas. I mean, you can't protect the underlying subject matter. If you're teaching math, the Pythagorean theorem's the Pythagorean theorem. But if you've explained it in a creative way and you've got graphics and things like that, that added on, that expression stuff is yours. It's subject to copyright. And if someone has, cut and pasted that stuff instead of doing their own work.
Copyright has to be fixed, what they call fixed. So if we're now just here standing and talking, or like a fella singing it in the shower, tough luck, But if you have, let me say, a teaching plan, and you've written it out, and you can see that somebody else is using the same or very similar or pieces of that teaching plan, the answer is that they are, quotes, infringing, close quotes, your copyright. The next question is, you want to sue them? And for what? 10 cents? An apology? Public kicking in the head? Just what kind of compromise you want to make? Often you see people saying, and I acknowledge that I got this stuff from so-and-so. And put that in there. You've seen that in newspaper articles, that the photograph was taken by John Smith and so on. Yeah, you want some recognition that they've derived it from you. And with a little bit of grudging stuff, they'll probably do that. People are always reluctant to, apologize. We know all about politicians not wanting to apologize and people not wanting to acknowledge that they actually got an idea or some pieces of an idea from somebody else. Tough. Sue them for money? Yeah, you can, but the money won't be good, and you won't put your kids through college on that money, you know. Yeah, to use a legal term, it pisses you off, right? Yeah. Right.
Things I have it all written out before I speak.
Yes.
He was telling me, well, if you have it all written out, you know,
Yeah, yeah. In Canada, you don't have to do much to get copyright. If you're a Canadian and you want to get U.S. copyright, okay, here's a little trick. Is you have to put your name and the year that you published this. So, Mary Smith, 2019, and the word copyright are seen in a circle. You've seen that all over the place because it's free. I mean, it doesn't cost you anything to do that, so why not? So if you've got a teaching plan and you're doing it, you say, that's mine. And you might even say to people, look, you may want to use some of this, but give me some acknowledgement for crying out loud, no? And some of them, unless they're complete jerks, and the world is full of complete jerks, will do it.
You may also have some luck if you're taking on students and teaching them course materials. When the agreement that you have when they sign up to take your class, presumably they pay you something and you have a little written document. Put something in there that they they can study from the materials, they can reproduce them for their personal study notes, but they can't republish them and use them to teach.
That's what I was going to add. And the other thing we found is that sometimes you may have, I don't know about your workshop, sometimes you may have also other people working with you, and they know all the the secrets, all the detailed information, how you run this workshop and that sort of thing. And with these people, sometimes they may just go off. They say they learn enough from you that they just go off, set up their own shop. And with these people, you can have more control. You can get them to sign up agreement with you, say they work with you, they are not going to compete, they're not going to set up a separate workshop. But then there, it just the wording has to be really very careful drafted. Say you cannot prohibit them, say you cannot do that in Canada. That's not going to work. If you go in front of Justice Hughes a few years ago, he will say, no, that's not enforceable because basically you are saying you cannot make a living on this. But if you say you cannot do this 5 months from me, then probably that's going to work. Or if you say you cannot do that 3 months or 6 months or a year from the date you leave my employment, probably that can work. So it has to be looked at very carefully and carefully drafted. But that, of course, only work with someone who actually work with you. The students, it's going to be tough.
Thanks for all the information about Canada and U.S. Intellectual property. I guess my question is, with the global economy the way it is, it's pretty easy for someone in Canada to then be selling their products worldwide. And it scares me. Do we have to go through this in every country? Does like the European Union have its own copyright? Can someone speak to that a bit?
Yes or no, as always, if you ask a lawyer. In one thing is if oftentimes they would look at, so if we just put this on internet and you say, okay, someone come to buy it at your website, the local court will look at you and see whether you actually made a presence in their own jurisdiction, and they will look at many different factors. And if we just isolated sale, oftentimes the court will think it's as if that person traveled to Canada and bought this from you. But if you make an effort targeting that market, say I make, here's some local phone number you can call. You don't have to call my Canadian phone number. That number actually will transfer to my Canadian office, but it's a local phone number. And if you, even worse, you set up this local warehouse And in that kind of situation, the court most likely going to say, okay, you are actually in my jurisdiction, in my country, in my province, or whatever that might be. And in which case, you better make sure that everything will comply with that local law.
Yeah, international is expensive. Don't kid yourself, you know. If you want to send a few things to the U.S., then you've got some advice to Sean about that. But if you want to sell it in Uzbekistan, for instance, it's going to cost you some money to do it. Now, you're either going to have to take your chances and go in naked, if you will, or else you're going to have to spend some money. And usually people who are spending money try to partner up with somebody who's got some international corporation or something like that, because it's far too expensive. For a patent, for instance, you can file a patent application. There's a thing called PCT, Patent Cooperation Treaty, and you can file something, let's say in Canada, and by paying a fee called small fee, but if you think $20,000 is small, then you're doing okay. But if you think it's big money, then you shouldn't be doing this, you know. You can get a place in line in up to 183, I forget the number, but it's very close to that, countries that say, yes, we'll give you a patent if you qualify in Canada and so on, but you're going to have to spend money in Uzbekistan and Botswana and every other place if you want to do that. And that's only for the very big boys. It's not for you if you're making homemade candles, you know.
That was actually going to be one of my questions. Just I've seen a lot of companies that I know personally who will take a product and it becomes bestseller on Amazon. Amazon's global, all over the world. So we touched on industrial designs earlier. So would it be the same scenario there if they had like the toaster that was a spaceship? Would you have to basically industrial design it in each territory? Or how would that work?
Yeah, if you want to enforce a monopoly in a patent or an industrial design or something, you have to have protection in that jurisdiction where you want to insert the monopoly. With patents as an example, if you have a Canadian patent, you have the right to make the invention in Canada, use it in Canada, and sell it in Canada. If somebody makes it in the States and sells it into Canada, they're infringing because they've sold it in Canada. If they make it in the States and sell it in China, and you've only got a patent in Canada, there's nothing you can do about it. So you pretty much want to protect, you know, by getting patents or industrial designs in your major markets, and also possibly you want to think about countries where it's likely that manufacturing will take place. So if you get a patent in China, then they're not going to be able to manufacture stuff, you know, cheaply and ship it all over the world if you can assert patent protection against the manufacturer there.
Yeah. Don't forget, you don't have to patent something. It's a way of getting protection for what you've got against other people who might want to do the same thing. If you're prepared to let it go, then do it. For instance, toys are like that. Hula hoops, you know, they have a 2-year lifespan. Why bother getting a patent? The expense and the time, you know, to get a patent, ballpark, you file on day one and you get a patent in 3 or 4 years. It takes that kind of time. So if it's a 2-year lifespan toy, why bother? So it's not that you have to, but the question is whether you should.
Okay, I have a question about the product. Okay, usually we have one product and only just like maybe 10% is your own idea. So you apply patent, but the rest of them maybe use some parts. That part may be applied by some patents, but actually sometimes you don't know. So what we can protect ourselves, but like, oh, later on, oh, that's my patent, so you're against my blah, blah, blah. So how can we think about the whole thing for the product? Thank you.
Okay.
That's a tough question.
Yeah. Actually, I think probably I should refer back to Justice Hughes' slides at one point. When you get a patent, you actually don't automatically have the rights to produce that product. And that might be, as Justice Hughes mentioned before, it might be a variation or the improvement to another idea. So all that patent gives you is not for you to have the right to produce it, but rather give you the right to tell other people not to make it. And if we turn the table, then it's the same question. If other people have a patent, then you better get all this clearance. That's what I mentioned as a FTO. Make sure that you look at all the components, that's 90% of your parts, that either the patent already expired or there's no patent coverage at all. If there is, then you buy this from the right source, in which case the rights will go to you, hopefully. Make sure that you read that agreement carefully. Or you get, if you make it yourself, make sure you get a license from whoever owns the patent, unless you're certain that patent is invalid. For example, they sold the product a year before they started applying for the patent. Yeah.
Sorry, sometimes confuse me. Okay, for example, we all know 1 + 1 = 2, right? But right now we just say, oh, okay, we try to create a 1 + 1 + 1, that equals 3. So, but everybody knows 1 + 1 = 2. So how can I say, oh, back to the thousand years, we have to get that license from them? You understand what I mean? So that's sometimes confused. For example, so for products, right? But the box and also the light, whatever. So sometimes they patent already, but we just buy some like original commercial products put together, right? But we don't know which one belongs to which. So how can we consider the whole thing? So sometimes it confuses me because I don't like, okay, for example, it's a school, right? So we buy a school, but some people, oh, this is a special school, so you have to get a lesson from me, so otherwise I will sue you. Sorry.
You can have a patent apply to the smallest part of a large thing. Everybody here has a car. Practically everybody has a car. Have you ever turned on the windshield wipers? And the windshield wipers, you turn it on and it will go to intermittent just a little bit, and then you click it again and it goes fast. And in some cars, you can actually dial it up to go anywhere in between, just a little bit and fast. Well, somebody had a patent on the dial it up to go fast or in between. They still sold cars, but in Canada, certain car manufacturers who didn't do a deal with the guy who had that patent had the 3 clicks, whereas the car you bought in the States would have had the dial-up, okay? So if it's a component, has many, many parts, patents may relate to one. I've got an iPhone. Maybe you've got a Samsung phone. On my iPhone, I can swipe like this and it'll bounce back. On a Samsung, try that, okay? Again, Apple has a patent on that particular feature. Samsung has avoided putting that feature in some of its phones, okay? So you'll find there's a very sophisticated, big companies have got hundreds of lawyers dealing with patents just to find out what small patents they can or cannot observe, where they have to take a license, where they have to change the design, but just for Canada, and that sort of thing. It's not an easy game. It's a tough game.
Just have a question about not wanting to infringe on someone else's copyrighted intellectual property, or For an academic paper, it's easy to reference. For a blog post, it's easy to reference. When I take a concept that I've learned in education and I want to teach other people about it, but not just exclusively that context, I'm trying to teach them how to apply those principles into their workplace training or different creations. I will reference where that original information, that's the easy part. But when I'm selling a course or a workshop or a service, I don't know, should I go to that person, ask permission, or when I'm profiting from their researched work, but I'm going well beyond it. I'm not just talking about that. I just don't want to infringe and do something wrong in that way too.
I'll start off anyway. Infringement of copyright means the taking or the copying of a substantial part of a work. So if you're taking, a paragraph here or there that has a juicy quote in it that they capture the expression you want to use it, you can take that little piece. You should give credit. And that's not a substantial taking. It's not a copyright infringement. But if you take a whole lesson plan and whatnot, then you should be getting, consent for it. And as most things in law, it's a gray area. I mean, you have to look at substantively, like, how much of the substance has been taken. Did you take the most important parts? In that sense, is it a substantial taking? Or are you simply looking at, just taking a little bit? And you can't just randomly say, okay, I only took 10%, so therefore it's not substantial. You've got to look qualitatively at the importance of what you've taken.
So
Maybe yes and maybe no.
it might be a good idea to maybe go to the person that researched that concept just to make sure.
If you can, it's always, ask.
The concept, and then I'm trying to teach people how to apply that.
Yeah, if you can, get permission.
Okay.
That's the easiest way.
If you can find it.
I just want to ask, having been down that road a bit, how litigious is that kind of thing? Because the problem with going and trying to get permission from someone is suddenly they see that there's value where there isn't, and then they overvalue what it is, and you end up not using it. And so the other option is to just use it and acknowledge them, but then see if they want to pursue a lawsuit or send you a letter that says, we don't like you using this, because a lot of times they don't actually care. They're a little flattered, and in some of the stuff I've been doing, it's easier to do that than actually try and get permission, because that can end up not so good.
Then you're tipping them off before you do it. I guess, if you've taken a chunk of something and you've published it, if it's enough that someone's ticked off about it, what they're going to do is they're going to go to their lawyer and they're going to say, this person copied, pages 14, 17, and 22 of my work and these pictures, and I'm ticked. So the lawyer will send you a nasty letter telling you that you've copied that and, demand that you remove it from everywhere. And then you're going to send it to your lawyer. They're going to look at it. They're going to see if there's some weaselly ways around it or whatever. Maybe there's some exceptions or something. Weasel. So, sorry, eagle way. And then maybe it comes to, your lawyer talks to my lawyer, and if he gives you credit for it and he takes it out of the next publication, is that okay? Or if he pays you, a couple $1,000s, are we good? The Copyright Act does have what are known as nominal damages that are sort of set in there, and there's a set minimum and maximum per infringement. So, if you can't prove any commercial losses, then that's kind of the guideline that you look at for how you negotiate.
Okay, well, I have one question, and this may be the final question of the evening. And this may have been answered, but I just want to make sure. So if, as a writer, you publish a book in Canada and you publish it or you want to sell it in the U.S., or if you write a song and you do it in the U.S., selling albums or whatever, do you need to copyright that work in the States as well? Or does the copyright just carry through?
The trick is the word need. You need to know. We have an agreement with the U.S. If you have copyright in Canada, you get it in the U.S. But the U.S. says, in order to sue, you've got to put the notice. Remember I said your name, the year, and the word copyright or C in a circle. That's in order to sue. So sure, you can sell your book, you can sing your song, you can do all that stuff. You don't need. Should you? Is it a good idea? Yeah, it's a good idea. And because it's so cheap and dirty, you've put your name and the copyright in there. Yeah.
Twirl the mic. That's right. Be careful. The weasel. No. So just a quick couple thank yous. This event, thank you to the Small Business Enterprise Center in Niagara Falls. We're Spark Niagara. We'll be having more of these panel discussions in the next months. Thank you to Digital Tree. For any of your digital marketing needs, please visit their website. They have live streamed this all, so we can look back online tomorrow morning. We'll post the links so we can watch any of the questions and review any other items. And of course, thank you to the Intellectual Property Institute of Canada and our 3 lawyers here. Roger, thank you. Valerie and Sean, you answered all our questions and your insight is very valuable. We really appreciate your time tonight. Thank you.
I just add, the Intellectual Property Institute has left some literature over on the table if you want to grab some free stuff. On your way out.
Awesome. Thank you all very much and drive safe home.